If you're an employee or an employer in Canada, you may be surprised to learn that there likely is no law that regulates employee privacy in your workplace. I can't find exact stats, but the odds would be less than 50-50 for any particular employee in Canada. In my experience, many people in Canada assume that they have statutory privacy rights in their workplaces, but most simply don't. We have a patchwork of privacy laws, and only some of them cover some workplaces. What I hope to do here is provide an overview of what this mosaic of privacy law looks like and where the gaps are for employees in Canada. Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGinnis Cooper. I should note that my firm exclusively advises businesses and employers, so if you're an employee with a privacy issue, I simply can't help you. As I mentioned, we have a mosaic, or a mess of privacy laws in Canada. Canada is a federation, and jurisdiction over certain subject matters is divided between the federal government and the provincial governments. So we have 10 provinces and 3 territories. And we have 4 distinct employment sectors, which are each subject to different regulations from a Canadian privacy point of view. And across all of those chunks, there are spots with no privacy regulation at all. These gaps are because most provinces have decided not to step up and create privacy regulations in the workplaces that they have jurisdiction over. So we need to divide things up between the public sector and the private sector, and then each of those get further divided between provincial and federal jurisdiction. We have a federal public sector and a federally regulated private sector. Workplaces in both of those sectors have privacy regulations, but it really is a small portion of Canadian workplaces. We also have the provincial public sector and the provincially regulated private sector. There are privacy regulations for the provincial public sectors, but most, but not all, provincially regulated private sector workplaces are without privacy regulation. Each province and territory and the federal jurisdiction has a public sector privacy law. This generally regulates how the provincial or territorial or federal government can collect, use, and disclose personal information. They apply to citizen information, and they apply to public sector employees' information. How far these extend vary. Most provincial privacy laws also apply to municipalities, school boards, universities, health authorities, and the like. The federal public sector privacy law, the Privacy Act, extends to all core government institutions or ministries, and also to each designated government institution that's listed in the schedule to that act. This includes institutions like the Royal Canadian Mounted Police and port authorities. We have 14 different privacy statutes that regulate the public sector, 4 that regulate the private sector, and about a dozen that specifically regulate the health sector. Now, the health sector laws generally don't have much impact on the workplace, or at least the relationship between employees and employers. There's little doubt that the federal government can pass laws that regulate itself and all of its subsidiary activities. The same goes for the provincial governments. The private sector is different because there are different parts of the private sector that come under different regulatory jurisdictions. So in Canada, we have a category called Federal Works, Undertakings, and Businesses, which fall under the regulatory purview of the federal parliament and the federal government. So for the purposes of this discussion, they are federally regulated employers. This category includes airlines, interprovincial or international transport, shipping, telecommunications, banks, things like that. If the workplace is subject to the Canada Labour Code and not a provincial equivalent, then it is a federal work undertaking or business, and the collection, use, and disclosure of personal information about employees is regulated by our federal private sector privacy law, the Personal Information Protection and Electronic Documents Act. The federal parliament simply does not have the jurisdiction or legal power to regulate provincially regulated workplaces. Trust me, I think that they would if they could. So if a private sector employer is not federally regulated, then it's out of the reach of the federal law. Provinces can impose privacy rules for those provincially regulated workplaces. But the reality is that most of them have not. Now, currently only 3 provinces have privacy laws that regulate how provincially regulated employers collect, use, or disclose personal information of employees. That's British Columbia with its Personal Information Protection Act, Alberta with its own Personal Information Protection Act, and Quebec with its act respecting the protection of personal information in the private sector. This means there are no privacy regulations for provincially regulated private sector employers in Manitoba, Saskatchewan, Ontario, New Brunswick, Nova Scotia, Newfoundland, or PEI, and there are no private sector privacy laws in the territories. And that's a lot of the country. That's a lot of the workplaces in this country. Now, where there is a privacy regulation in the workplace, you may be surprised to learn that consent is not at the center of the regulation. Compared to how our general commercial privacy laws apply, these work differently. In the public sector, government institutions and public bodies can collect, use, and disclose personal information based not on consent, but based on legitimate, lawful, and reasonable purposes. In the private sector, it's generally based on notice of purposes and reasonableness. Consent sometimes comes into play, but mostly deemed or implied consent. So here's the general scheme from the Federal Privacy Act, which regulates the federal government and government institutions. At Section 4, it says, no personal information shall be collected by a government institution unless it relates directly to an operating program or activity of the institution. So it has to relate directly to an operating program or activity of the institution. That can include employment. And the institution is required to give notice of the purposes for which the information is being collected. This is from Section 5, Sub 2, which says, a government institution shall inform any individual from whom the institution collects personal information about the individual of the purposes for which the information is being collected. And once it is collected for any particular purpose, it can only be used for that purpose or for a compatible purpose, or according to one of the many exceptions set out in subsection 8.2. So at Section 7, it says personal information under the control of a government institution shall not, without the consent of the individual to whom it relates, be used by the institution except A, for the purpose for which the information was obtained or compiled by the institution, or for a use that's consistent with that purpose, or for a purpose for which the information may be disclosed to the institution under subsection 8.2. We can contrast this to the way it works in PIPEDA for federal works undertakings or businesses. Under that law, the general rule is notice and voluntary consent. But Section 7.3 changes that for employers. It says a federal work undertaking or business may collect, use, and disclose personal information without the consent of the individual if the collection, use, or disclosure is necessary to establish, manage, or terminate an employment relationship between the federal work undertaking or business and the individual. And also the federal work undertaking or business has informed the individual that the personal information will be or may be collected, used, or disclosed for those purposes. So no consent is required if it's necessary to establish, manage, or terminate the employment relationship. And the purposes have been identified to the employee or candidate. Now, British Columbia and Alberta's laws apply similarly, meaning the purpose has to be reasonable for managing the employment relationship, and the employees have to be given notice of those purposes. Quebec differently and largely runs on the legal fiction of implied consent and generally works out where the purposes are reasonable and the measure is not too intrusive. Now, I'll wrap this up with a brief word about unionized workplaces. Collective agreements can't override the law at all, but it's not uncommon to see collective agreements with privacy-related provisions. Where they exist, they generally hem in what employers can do with personal information or put limits on workplace surveillance. And while each of the privacy laws I've referred to are overseen by privacy commissioners, labor arbitrators are called upon from time to time to consider privacy laws. Often this is in the area of workplace surveillance, and it's not unheard of for a labor arbitrator to have to consider statutes like the Personal Information Protection Act in connection with an arbitration. As I said, it's a mosaic or a mess of privacy laws in Canada, particularly as far as the workplace is concerned. I hope this has been of interest. The discussion was obviously at a pretty high level, but hopefully provided a general overview of the lay of the land for workplace privacy in Canada. I try to put out a new video every few weeks, so if you're interested in this sort of content, please click the like and subscribe buttons. Also, leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian tech and privacy law. Thanks for tuning in.